So, dear friends, it's a very exciting moment. It's like, I don't know, 20, 30 years ago, it's like when I got the driver's license, first time in the car, It's a little bit the same feeling now, 2 years almost in podium. So, for Martin Center, it's a sign that the epidemic is over and we are going to back in business and our usual discussions. In the room, you don't see so many people now, but they was just to tell that we were still following a little bit of fully the current restrictions what we have in here in Brussels area, also in terms of participation. But very happy to welcome you in person and very happy to have this discussion, which will be one of many which take place here in Brussels with Martin Center now in autumn. Now, a topic of our conference today, the Refugee Convention, does it still matter? And of course, the topics of refugees and immigration are very tightly connected. During the epidemic, the refugees and as a topic and the whole immigration debate was not much on the table for obvious reasons. But as we can see, the recent events in Afghanistan and then the consequent discussion on what are the implications to Europe, we see that the whole issue of refugees and all the questions related are very topical. Now, basically the discussion today is our research paper, which we are going to discuss and present, which is available online. Back to Geneva, the Refugees Convention, does it still matter, which refers very much on the topic we are going to discuss. As it comes to refugees, the whole question of their rights and how the situation when a potential refugee comes to Europe is regulated in essence by 1951 conventions relating to the status of refugees, the so-called Geneva Convention. And of course, especially in 2015, as we remember the whole incidents related to the high refugee flows, not only from Syria but other parts of the Middle East coming to Europe, the discussion was very much in many EU member states whether this convention still is valid. The criticism or the argument goes that the Geneva Convention 51 was rather a reaction on to post Second World War situation and rather made for that moment, like from lessons learned of that period of time. And now, 70 years later, that convention in essence is not updated. And this discussion was not only in one or two countries, but in various countries in very high level. But of course we can ask that okay, is the opening of Geneva Convention, is it a really realistic option? First of all, many, and I think all of us here, believe on multilateralism, believe on international agreements, and all the discussions which is taking place also here in Europe. Does it make sense to really open the debate? Number one, and number two, is it really realistic in this situation where the interests are very different in many different parts of the world to have really an agreement on a new convention? And rather, and that is where our research paper, of which we are very enthusiastic, is focusing on, is really not, is to look the interpretation of the Geneva Convention and look, what was the essence, what was the context when the Geneva Convention was created, but more importantly, what has been the interpretation, and interpretation especially as it comes to Europe and the concrete application of that. We are going to speak about also how how different the interpretation has been in different parts of the world: United States, Canada, Australia. And one thing I want to very clearly mention, especially as we are also online, is that in these weeks big discussion is taking place on Polish Constitutional Court judgment and challenging EU's Court of Justice supremacy. So this is totally different discussion. This discussion is taking place fully recognizing the institutional framework, EU Court of Justice, European Court of Human Rights, Geneva Convention. In fact, I would go a step further. I would claim that this paper in its discussion it actually strengthens, that argumentation strengthens the Geneva Convention as a base for finding a solution also in this challenging situation. So in short, so does the convention still matter? What part of the current application really derivates from the Geneva Convention itself, and what part from the European Court of Human Rights and European Court of Justice interpretation of it, and what should be then the conclusions of that as we look for the future, as we look for the future implementation of a refugee convention. Once again, I would like to thank you all, our speakers online, but we are going to have here in the room, I'm sure, a very interesting discussion in person. I would like to thank Vic Novotny, who has been from our side the kind of the mastermind of the research project. I would like to thank the authors who are also participating on discussion, and of course you coming here to this discussion. So welcome you all, also welcome you online viewers to our first in-person debate, and with Novotny, floor is yours.
Thank you, Tommy. Ladies and gentlemen, dear physical and virtual guests, the great Brussels comeback has begun, and the Martin Center is proud to be at the forefront of this movement. I would like to introduce our speakers and co-authors of the paper we are featuring today, Back to Geneva, Reinterpreting Asylum in the EU. The paper is available on the website of the Martin Center, and its paper version is being printed. Connecting from Bratislava is Vladimír Šimoniak. He is currently head of the Crisis Management Unit at the Slovak Ministry of Foreign Affairs. Previously, he was with the Slovak Ministry of the Interior, including a 6-year posting here in Brussels. Connecting from Prague is Harald Christian Scheu. Harald is a lecturer in European law and public international law at the Faculty of Law of Charles University and the Police Academy of the Czech Republic. He is also a member of the Czech government's Legislative Council. The Martin Center did invite a representative of the United Nations High Commissioner for Refugees, UNHCR, here in Brussels, but this invitation was declined because of other commitments. This event is scheduled to take 60 minutes. You, our participants, can ask questions of our speakers. If you are physically in the room, please simply raise your hand when the Q&A session begins. If you are following the event online, that's on YouTube or on the Martin Center website, you can start asking your questions now. You can ask those questions either on the YouTube page where the event is being broadcasted in the comment section, or you can use any of the social media that the Martin Center runs, Twitter, Facebook, and others. Without further ado, I would like to ask our two speakers and co-authors of the paper to present their initial remarks. We will start with Harald Scheu. Harald, the floor is yours.
Thank you, dear participants. First of all, I would like to express my gratitude to the Wilfried Martin Center, the organizers of this event, Vic Novotny as the editor of our paper, and also Vladimír Šimoniak as the co-author of the paper. It was a real pleasure for me to participate in this project, and I'm really proud of its outcome. Current refugee movements to Europe are part of global migration. This means that the status and the protection of refugee is not only a bilateral or a regional European issue, but a genuine multilateral agenda affecting countries in all parts of the world. In our paper, Back to Geneva, we have focused on the most important international treaty on refugee law, the famous Geneva Convention, and its relationship with EU law. The Geneva Convention was signed in July 1951, that means 70 years ago. Apart from some temporal and geographic limitations which have been removed by the 1967 protocol, the main provisions of the Geneva Convention have remained unchanged until today. It looks like a very consolidated treaty. However, from a historical perspective, the concept of international refugee protection was always a subject of political and ideological conflicts. For example, between the wealthy industrial countries and poor developing countries, or between the antagonists of the Cold War. This means that although today there is more than 140 states parties to the Geneva Convention, the treaty does not express an undisputed and unchanged or unchangeable universal consensus on the content of refugee law, but it is open to different interpretations. In the context of EU law, different issues which are regulated by the Geneva Convention have undergone a dynamic development. In addition to the rather narrow refugee definition in Article 1 of the Geneva Convention, EU directives have introduced the concept of subsidiary protection for third country nationals who do not qualify as refugees in a legal sense, but who face a real risk of suffering serious harm in their countries of origin. In this respect, we may say that protection under EU law goes beyond the standard of the Geneva Convention. As for the question of illegal border crossing and illegal stay within the meaning of Article 31 of the Geneva Convention, the EU so far has not established a model of safe legal venues for refugees. However, on the level of individual EU member states, a limited resettlement capacity has been created. Also with regard to the principle of non-refoulement, which is maybe the most important rule of the Geneva Convention, EU law goes beyond Geneva law, because unlike in the Geneva Convention, the standard of protection under EU law is absolute and not relative, as in the Geneva Convention. Therefore, in EU states, the non-refoulement principle may be invoked also by those refugees who pose a danger, a risk to the security of the receiving country. These modifications suggest that as far as the interpretation of legal concepts is concerned, the Geneva Convention may be approached in two basic manners. Firstly, the Convention can be understood as a living instrument of international refugee law. This means that the interpretation of the Convention needs to reflect present-day conditions rather than the original understanding in 1951. Such approach frequently links the Geneva Convention to the major human rights treaties and creates liberal solutions based upon aspects like fair procedure, family life, or social rights. Secondly, one can also rely on rather conservative treaty interpretations, which are based upon the original meaning of the text, the original intention of the contracting parties, and their consistent long-term practice. Such interpretations mostly lead to a rather restrictive understanding of refugee law. As we have seen in our study, the EU Court of Justice more often sticks to the first approach. Therefore, the current standard of the common European asylum system seems to be more liberal than some provisions of the Geneva Convention. However, these diverging standards are not only the result of liberal judicial interpretation. In principle, the definition of subsidiary protection was a matter of legislative choice. This means that higher standards of protection are very often introduced by political decisions taken by the competent EU bodies. This is also true, for example, for the so-called Asylum Procedure Directive, which provides for various procedural rules which are not contained in the Geneva Convention. Indeed, we may point at very topical questions of refugee protection which are not sufficiently dealt with by the Geneva Convention. The rules of the common European asylum system are definitely more complex than the Geneva Convention. Besides the field of asylum procedure, we may point, for example, at the tricky issue of solidarity and international cooperation. The EU has reached some very fragile compromises, for example, with respect to the so-called Dublin system, the common rules for the return of unsuccessful asylum seekers, and some short-term relocation mechanisms. As the Geneva Convention is silent on such issues, it may seem that it does no longer serve as the Magna Carta of refugee law, and that it has been partly replaced by European rules. Nevertheless, as refugee movements and refugee protection are not only European but a global problem, we have suggested that back to Geneva does not mean applying a 1951 convention in its original meaning. But this slogan might suggest that EU actors, and especially the EU Court of Justice, should apply those rules of the Geneva Convention, which are still relevant, as genuine norms of public international law, and not only European law. In its judgments, the EU Court of Justice rather pays lip service to the Convention instead of thoroughly interpreting its provisions as part of international. We consider that it might be very helpful if European courts took into account the case law of US, Canadian, and Australian courts. In the light of current state practice in different parts of our world, it appears that the Geneva Convention is not an outdated standard, but still an important point of reference for all its contracting states on the global level, not only on the European level. Thank you.
Thank you very much, Harald. I would now like to give the floor to Vladimir, connecting from Bratislava. Vladimir, the floor is yours.
Greetings, everybody. Hope you're doing fine. It's an exciting feeling to be part of something that's happening in person in Brussels after some time, even though I'm myself connecting remotely. Let me take a personal angle on the issues at hand a bit. I have myself become involved with migration policy, and more particularly the European aspects of it in 2011, so 10 years ago. And almost constantly, the feeling I was getting in Brussels and elsewhere was that the outcomes were not matching the expectations of the political leaders and also of officials, and certainly not of migrants themselves and other people directly involved in the events on the ground. It would be a cheap way out to point out to the climax of 2015, but in a certain way, that was just a climax of something that had been ongoing for years, and in fact is not history yet. So these 10 years have also been on the basis of that perceived discrepancy between expectations and outcomes. These 10 years have been time of almost constantly ongoing legislative negotiations. The current generation of EU asylum law has become enacted in 2013. Even before the directives could have been transposed into national law, we received a package of proposals aiming at supplanting it. Last year, we received another package of proposals meant to overhaul the whole EU asylum law. So my perception is that we have engaged in many exhausting, I mean officials or member states, but to a large extent also political leaders, parliaments, and the public at large, very certainly also the members of the Brussels think tank and policy advice environment. We have engaged in exhausting and long-lasting debates, analysis of almost all imaginable policy solutions and policy proposals that relate to asylum and migration. I mean, some of them had been considered absurd even a few years earlier, and then they became part of the mainstream debate. So I feel that a lot has been discussed over the past 10 years. And, you know, when that happens, there are elements that come back constantly and so sort of become very stealthily, even without noticing, they become, part of the debate that's not going anywhere. And the Geneva Convention was, in my perception, a similar presence in the room. Many solutions have been rejected in the negotiations for being quite obviously not legally viable. But that also repeatedly brought to the table the issue about, why exactly those solutions are not legally viable. Is it really the Geneva Convention, or is it something else that makes it that or some other path of thinking really not a good prospect for progress? We have also had emerging thinking at global level, actually, about whether or not the Geneva Convention is enough. We have had a process leading to the adoption of the Global Compact on refugees in 2018, which sort of implicitly bears the idea that the Geneva Convention, despite it being a very respectable document, might not contain all the answers to all the questions that had emerged in recent years. So, the Geneva Convention and its relation to the perceived disparity between expectations and outcomes has been sort of constantly present in the room. And it struck me as peculiar, to be honest, because the Geneva Convention is a global instrument, and that perceived discrepancy between expectations and outcomes seems to be a particularly European phenomenon. In fact, I would struggle to find an example of another major democratic jurisdiction that would, have asylum as a major political topic for years. And so for this reason, I repeatedly turned to the why and how is the Geneva Convention part of the agenda as we were dealing with it. And I'm really thankful to the Wilfried Martens Center and to Reed in particular for enabling me to delve into that from a bit less, let's say, official-like position. So to allow me to have a step back and look at it from a more academic, more legal perspective than I usually, as a national official, can allow myself to take. So, and obviously, I also thank Harald for being my counterpart and my partner in this project and in writing this paper, because it's been an exciting experience for me, an enriching experience for me, that I would like to repeat at some point, perhaps. And I'm not going to exhaust all of you by going through the papers. I think Harald has made several, actually most of the most important points. But from my perspective, maybe two things that I would like to highlight is first, that the Geneva Convention is actually silent on very many issues that characterize the functioning of the asylum system that we have in Europe. Nonetheless, the Geneva Convention does provide a rather coherent vision of how asylum should function. The European legislator, the EU legislator, has provided us with many supplementing rules, many actually also to an extent differing rules. But I don't feel that this level of detail actually adds to the coherence. And I feel that a lot of the debate that we've been having in the Council and between the Council and the European Parliament over the past years were really focusing on things that might not in the end be really that critically necessary for operational efficiency. That is another recurring thought that I'm experiencing. And the second point, which brings me back to the title of today's event, the Geneva Convention, does it still matter? I would be, maybe the cheap way out would be to say yes, it does, which undoubtedly, in my view, it does. But I would even say that I wish it would matter more. I think it's one of the outcomes of the paper, from my perspective at least, is that I would really prefer the Geneva Convention to be taken way more seriously and to have a much more prominent impact on the practice of asylum in Europe. So that would be probably it from my side. Again, thank you everybody for the cooperation, and I'm looking forward to all the questions and the debate. Thank you.
Thank you, Vladimir. Before I will start taking questions from you, our audience, I have a couple of questions myself, but first I want to ask our two speakers if there is anything you want to add to what the other speakers said so far, if there's anything you would like to comment on. If that's not the case, I have one or two questions myself. I want to ask about the question of reforming or renegotiating the convention. This is not something that was addressed in our paper. Different people come from different corners with an idea that the Refugee Convention somehow is not adequate anymore. And you suggested some areas where perhaps it is not perfect. So some people are asking to enlarge the scope of the convention to take account of climate migration and climate refugees who perhaps at some point in the near future may start fleeing their country of origin and head to other areas. So that's one angle. The other angle would be the Refugee Convention is far too generous. It forces governments to accept people, accept refugees who perhaps they shouldn't have to be accepting. So the impetus for the reform or the calls for the reform of the convention come from different corners. But I'd like to ask your view. Is this something that should be considered? Is it a good idea? And maybe each of you is going to have a slightly different angle on it, but I'd like to perhaps hear your views on it. And you can volunteer to the extent that you're interested in volunteering for now. Harald?
Okay, thank you for this question. Of course, as you already suggested, it goes somehow beyond the paper, but it's very important. It's very important to think about the future of the Geneva Convention and whether it makes sense to think about reform. And indeed, there has been some suggestions in the past on the political level that the Geneva Convention should be somehow renegotiated. I think, as Vladimir already suggested, there are some crucial issues on which the Geneva Convention is silent or not clear enough. And I think if we started to renegotiate the Geneva Convention, the discussion would focus maybe on three most important items. The definition. The definition is outdated. It has been overcome by the European definition, but some states are somehow reluctant to adopt the European view. So we have many countries in the world which still apply the very narrow definition of 1951. So shall we include the European concept of subsidiary protection, for example? Shall we deal with climate refugees? Or how shall we deal with economic aspects concerning migration? So this would be one issue that would be really negotiated. I think it's not very likely that the countries would reach on a common approach on this question. The second issue, and this is the most important issue on which the Geneva Convention is silent, this is the legal venues. How to get to a country of protection. And this is a paradoxical situation, not only for Europe. The more liberal standards you have in the country, the more generously you deal with refugees, the more strict those countries will behave at the borders. And they will try to prevent people from coming to this country. And some experts on migration law, they called it a game of cat and mouse. First, it started at the borders, at the physical borders, and the states country said, as long as you do not physically cross the borders, you are not a refugee. It also applied to the transit zones. Then there was pressure from non-governmental organizations, and the court said, no, this approach is not wrong because this is already under your sovereign control. So as soon as a person gets to your borders and cries and shouts asylum, you have to start the procedure. So the reaction of states parties was to move the border controls somewhere to the high seas. Then they were told, in the Hirsi case, we analyzed the Hirsi case in our paper. So in the Hirsi case, the European Court of Human Rights said, no, this is wrong because if you exercise effective control in the area of high seas, you are responsible. So what is the next step? The states will move the border controls to the territory of third countries. They will conclude treaties formally with Libya or today with Morocco and some other third countries, Turkey, for example, saying they will exercise the effective border controls to prevent potential refugees from coming to our territories. So this is an issue. And again, I'm quite skeptical whether renegotiation of the Geneva Convention could lead to an acceptable international provision in the Geneva Convention. But this is indeed maybe one of the most tricky issues that we have to deal with. And a third issue, which has already been mentioned by Vladimir, the issue of solidarity. Actually, there is the preamble of the Geneva Convention, which makes some reference to the necessity, it's necessary to consider mechanisms of solidarity. However, they have not been included in the normative text. And I don't know, if we start a debate on the normative text of the Geneva Convention, including mechanisms of solidarity, how should they look like? Financial help, relocations or resettlement, or what to deal about the very often quoted root causes? Shall the Geneva Convention take into account the fight against the root causes of the refugee movement? So I think it's a very important question to ask after 70 years of the Geneva Convention. And I understand that this question is asked. But with regard to these three crucial problems not contained in the Geneva Convention, I'm very skeptical whether this could really work out on the universal level, on the level of the international community.
Thank you very much, Harold. Some questions are starting to come in, but before I ask that first question from the audience, Vladimir, do you have anything to add to what Harold said about the reform of the convention?
Yes, maybe just very briefly, not to hold off the other questions. In my experience, renegotiating international agreements becomes, sort of exponentially more difficult the more state parties are involved. And, just from formal, from the formal viewpoint of there being, I think, 140 state parties, this is almost undoable. So when it comes to climate refugees and other such people, that the emerging, moral consensus seems to be that they deserve protection, a structured and foreseeable way. What I would recommend is to explore ways of looking for a brand new instrument at international level, maybe at UN level. Just very low-key start of the debate, just planting the question of what should be done about inhabitants of some Pacific islands that might not exist 10 years from now, for instance. That probably could lead to a lot of the same questions a lot of the same solutions, perhaps, that we've seen in connection with the Geneva Convention, but maybe without the baggage and without the burden of the existing instrument and of different state parties having their favorite parts and less favorite parts, and every renegotiation being being a part or being a game of keeping the preferred elements and trying to do something about the others. So maybe looking at it from that perspective and recognizing the fact that climate refugees or climate migrants might be really a phenomenon that has a lot to do with refugees, but not quite as much as to be included in the Geneva Convention. And when it comes to the renegotiation of the convention for all the other elements, I think Harold made an excellent point, and I don't feel really anything should be added.
Thank you. I now have our first question from the audience. It comes from Maria Schick. And the question is, the African population will more than double in the next few decades. Will Europe be able to welcome tens of millions of Africans? Not strictly related to our topic, but perhaps the relationship between the Refugee Convention and this expected immigration is there, and I don't see it. Any of you would like to take that question? Vladimir?
Thank you. This is indeed one of the most crucial questions, I think, looking at the future of the EU asylum policy. But let me point out a few pieces of information that normally get become lost in this. The African population is increasing. At the same time, the level of affluence of the African population is increasing, which beyond a certain level of poverty actually motivates further migration. It causes people to migrate more rather than less. But what we are observing in the last decade, and I would even argue in the last 2 decades, is that the pace of increase of the African population is higher than the pace of increasing the pace of increase of migrants of African origin, which is a clumsy way of saying that proportionally less and less Africans are actually migrating. And when it comes to the patterns of migration, and this is an empirical fact, actually, there are organizations that have documented it much better than I can possibly now. And more Africans seem to be interested in migration within Africa rather than leaving Africa towards Europe. So if these trends continue, I'm prone to, exploring at least the possibility that tens of millions of Africans might not actually be that interested in coming into Europe, let's say 15 years from now. It's obviously a long time perspective for any definite predictions, but I think there's a quite some set of information that probably does not encourages some way more positive thinking about the future than seems to be usual in some quarters. Obviously, the African economies, the African societies exhibit a lot of fragility, and COVID has hit them extremely hard. The economies have been hit extremely hard, way worse than in Europe. So there is a lot of unknowns. But whether or not that question really relates to a probable future, I'm not quite sure. When it comes to the question of whether or not Europe will be ready to host such numbers of people coming from Africa or from wherever else, okay, let us not forget that asylum seekers are a rather small minority of people who immigrate into Europe. Every year, the European Union experiences the immigration of people to the tune of 1.5 to 2 million people. And most of them come via family reunification or other legal channels. Asylum is far from being the primary route of that immigration. And quite tellingly, few people seem to be, at the policy level at least, few people seem to be very much bothered by millions of people coming into Europe every decade. So the short answer, because I don't like avoiding questions, the short answer would be yes, if necessary. The actual question would be how that should be organized. And my recommendation would be not to focus on asylum in processing that migration flow. Thank you.
Thank you, Vladimir. We have one question in the room. Tommy, please.
Okay, there was one speaker wanted to comment, but okay, so I'd say, well, maybe we take that in first. No, you wanted to comment, yes.
Harald, please go ahead.
Okay, very briefly, because I do not have much to add to this very complex explanation by Vladimir, who is much more familiar with the situation in Africa. Maybe from an abstract perspective, I have to say that the European Union so far has not been dealing with the problem of the reception capacity, if there is some kind of upper limit. But if you remember, after 2015, this quota debate, the debate on the upper limits, has been started in Austria and in Germany, because both countries received and accepted a significant share of refugees coming in 2015. And in Austria, it was included into the national asylum law, a quota around 30,000 asylum seekers per year. And according to the Austrian law, all other asylum seekers should not be accepted. Their application should not be accepted. Actually, the number of asylum seekers declined in Austria, so this rule has never been applied. Nevertheless, it would be very questionable from a perspective of EU law. And I think EU officials have already explained that that kind of quota system, kind of upper limit, is not in line with the human rights standards of the European Union. So, but with regard to the concrete circumstances, so if you have a very high number of refugees, asylum seekers from a region, from a country, and the country feels that its absorption capacities do not meet this influx, then this debate will repeat on the national level rather than on the European level. And I think it's a very important debate because it's about numbers. Numbers matter, and this is another aspect that the Geneva Convention is silent about.
Yeah, thank you. Indeed, this debate on the numbers and then the national capacity to process asylum seekers, both legally and societally, so to speak, is often somehow in the background, and it's a difficult one for the EU and its member states to have. I think it's still ahead of us to have a substantial debate on that question. Tommy, please.
Yeah, just to kind of reframe, actually coming again back to the same issue where the speakers have already mentioned. So I just take back what we kind of, the question set in our invitation on, you know, how should they use national governments and European and national courts interpret the convention in light of, you know, the current situation. So reframing that again. So what, you know, so if we read the paper, one of the basic ideas to simplify it massively, and please correct if I'm wrong, is to say that the current interpretation of the implementation of the Geneva Convention actually do not derivate per se directly from the convention itself, the implications, but much has to do with the interpretation of the European Court of Justice and European Court of Human Rights. So what then, let's say in 5-10 years, no, we have started to have this, let's assume a scenario, let's say in one North African state, you have very high civil war, let's say, not mention countries, but for example, in a country where you have pyramids, let's assume something happens, you have a lot of people coming, and then the countries come to the political conclusion and that we cannot follow the current interpretation. And then they basically, to put it simply, have two choices. Either we just somehow abandon the convention or make some excuses not to follow it, or the other option then that the argumentation which you lie out in the paper that actually the convention itself, the interpretation we are doing now in Europe, it not necessarily the only option. So how much room to conclude, how much room of maneuver, in your view, the interpretation of the Geneva Convention gives to better match maybe the practical reality which could happen, for example, if there would be current crisis, but still that it would follow the legal framework and respect of the convention and law?
Thank you. Who wants to take that one? Harald, please go ahead.
Okay, thank you. Thank you very much for the question. So with regard to the interpretation of the Geneva Conventions, we have appointed two possible ways of interpreting the convention. A liberal one, very closely linked to human rights law, and a rather conservative way of interpreting the Geneva Convention based upon the rules of the Vienna Convention on the Law of Treaties of 1969. I think that both ways of interpretation are legitimate, and this leads to the conclusion that the Geneva Convention is applied differently in different parts of the world. I know this is very frustrating for national lawyers. National lawyers want their national law to be interpreted in a very clear and unequivocal manner. But in international law, this very often does not work. So European law is very close to national law. So when we have the EU rules on asylum law, then you want very clear answers, very clear interpretation. But this does not work that easily in the field of international law. In international law, both ways are legitimate, absolutely clear, and so there is space for the European Court of Justice and the national courts in the United States and Australia, for example, to find their own more liberal or more conservative approach. And unfortunately, this methodology of interpretation is not the only answer, because you can liberally, in a very generous manner, interpret the rules which are already laid down in the Geneva Convention. But when it comes to the legal venues, to the issue of solidarity, to enlarge definition of refugees and protected persons, you can expand that by interpretation. The European Union has done it by legislation, so it's a legislative choice. And of course, legislative choice can go beyond the Geneva Convention. It may accept temporal, it can provide, for example, temporary protection. We have a directive on this. Temporary protection might be a solution to the situation which you suggested, but it has never been invoked for political reasons. So we have the Geneva Convention, which probably will not be helpful, not even if it is interpreted very liberally, but we have parallel tools in European law, for example, temporary protection, which might be activated when it comes to the situation described.
Yeah. Thank you. I have another question from the audience, from our online audience. While the rhetoric in Europe about refugees is often alarmist, the numbers show that Europe takes much less than other, often poorer countries. Is this sustainable? Vladimir, please.
Well, comparing the contribution of Europe to the contribution of other jurisdictions, let's say, it is true that Europe takes in way less refugees than much poorer countries that happen to be close to the that happen to be close to the source of the migration to the country in conflict and internal turmoil. That is quite obviously the case. A good example would be Kenya, close to Somalia, being as a consequence the host to many Somali refugees. Again, that would be a cheap way out of pointing towards how much more Europe takes in refugees compared to Canada, the United States, other jurisdictions. That's not the way I want to take. Another way of relativizing this comparison would be to say that the kind of acceptance in several poor countries actually means that the refugees are allowed to exist in the territory without any sort of services being offered to them, without any sort of entitlements being offered to them. They are basically suffered to be in the territory, literally, like this. Whereas in Europe, the degree of, the extent of entitlements that is being offered to people who are not even recognized refugees yet is substantially higher. So that's why sustainability means different things in different places, I would say, from an operational perspective. Is that sustainable is, I think, a very relevant question in several specific situations. The first of them is, and we see that unfortunately in an increasing number of cases, is when the influx of refugees or displaced persons from a neighboring country threatens to destabilize the host country. A good example has been Lebanon for decades. There are, I think, other good, more obscure perhaps, but other good examples around the world. So this is where the degree, sustainability and the issue of sustainability becomes a very concrete political problem, I would say, and an issue to be tackled. In more general terms, whether it's sustainable that Europe would be taking in less refugees than some poorer countries, I would have to say that it has been sustained for decades. It has been a fact of life for decades that 3/4, give or take, of people who leave any country in a refugee situation stay very close to their homes, particularly because a situation like that leads to two main consequences. The first is a decay of infrastructure, be it physical or other infrastructure, which makes it risky and expensive to travel. And the second is the decay of livelihoods of those people, which makes it unattainable travel for many people. These are the harsh realities of migrants and refugees' life. So these people are just very simply not having the means to leave the region, even if they want it. This is what we see as a pattern. And we have seen that for decades, I think, on and on. It's a sad reality, but I think it's the reality of life.
Yeah, thank you, Vladimir. Let me check if there is any question from the audience here. If not, I have one of my own. We're now witnessing quite a dramatic situation on the EU external border, specifically the border of Poland, Lithuania, and Latvia, vis-à-vis Belarus on the other side of the border, and the attempt by the Lukashenko regime to first of all fly migrants into Belarus, into Minsk, and then transport them into the border of Poland, Lithuania, and it's a very difficult situation for those countries on the eastern flank of the EU that are facing this. So far, the EU bodies have supported fully those countries facing the influx of migrants, which has been engineered. In fact, in some cases, the asylum claims of the incomers have been processed. In others, the allegations are that the governments in question are not allowing people onto the territory in the first place, so as not to have to process the asylum claim. How would you square this situation, which is unfolding? How would you square the situation vis-à-vis the international obligations under the Refugee Convention? What would your view be? Vladimir, please.
Thank you. This is indeed a question. I would be actually quite worried if that question wouldn't appear, because it's really something that highlights many of the issues that we have been discussing in the paper in very stark light. Well, first, what is actually happening there? If you look at the numbers that we currently have, we see that less than a half, I think in the case of Lithuania, even less than a third of the people who are intercepted at crossing the borders claim asylum. All of the others do not seem to do so. At the same time, substantial numbers of those people arriving almost immediately leave those countries that they enter and end up actually in Germany. I think at the German-Polish border seems to be a hotspot of that. So this is the reality of the situation, and I think it very much highlights how the regime in Minsk has challenged the EU and the member state, the neighbor Belarus, in saying, okay, so you are claiming that you have these ideals that center around making international protection available to everybody who deserves it. So let's have a look at how you fare when the pressure is much higher than you are used to experiencing. And I think this weaponization of migration, this use of migrants as a tool, as a means of hybrid attack, is something that puts really some of the dilemmas that we've been discussing in very stark light. And it's sort of, before I leave the floor to Harald, it leads me back to some of the considerations that we have made both in the paper and that Harald has made some time ago. Because this is a new phenomenon. I do not quite, I mean, it's not entirely new. We've been seeing this in past years, but I do not quite picture the framers of the Geneva Convention originally imagining any such situation. Okay, that was just simply, I think, not part of the reality that they had experienced. I mean, forcing people out, yes, but forcing them as a means of attacking a neighboring jurisdiction was probably a new circumstance, a new idea to compare to the reality they inhabited. And given the possible two ways of exercising jurisdiction, let's say the more originalist approach, looking at the original intention of the framers, and then the vision of the Geneva Convention as a living document that takes into account both the emerging circumstances and, let's say, emerging moral consensus about how those circumstances should be understood. I think it would be quite interesting to see, under the living document theory, how possible interpretations could look like. Okay, and I think it would be something that, at least looking at new creative interpretations of both the Geneva Convention and of currently valid EU law, are something that political leaders might be confronted with very early, actually. Some of the basic elements of how we understand in Europe the Geneva Convention and how we understand our own law does not seem to be very well fit for the situation that has emerged. And it is not a given, in my perspective, in my opinion, it is not a given that further development of legal interpretation always necessarily has to lead towards more permissive, more generous, you call it the way you want, more liberal perhaps, understanding of those documents. I don't think this is really necessarily guaranteed, which is also maybe a contribution to the debate that has been initiated when pointing out the hypothetical situation in the southern neighborhood. Okay, this might also be a situation that challenges some of the notions that we have come to take for granted. But this is, I think, a much broader topic than I would probably like to cover right now.
Thank you, Vladimir. This is our last question, by the way. Harald, is there a comment you want to make?
A very short comment, because I absolutely agree with what Vladimir has already said in very clear manner. But the example of this example shows how dependent, how vulnerable the European asylum policy is. So we have become so dependent because we had to outsource our border controls. I tried to explain it with regard to hearsay. First at the high seas and then to the third countries. But when we rely on third countries, we become dependent and we can be blackmailed. So weaponizing the refugee movement is the current issue. And now we are too generous inside the system, so we are too strict outside. So we build fences, walls, we have the pushbacks. We understand that we are bound by the non-refoulement principle, at least by the non-refoulement principle. But how can this be enforced in a situation when we move from one extreme to the other? Inside, extremely generous, outside, extremely restrictive. So I think this will be a challenge for the future European asylum policy to reach a balance, maybe to make some points of the European asylum system less generous, and to, at the same time, to be less restrictive at the borders, and maybe to not have these strict walls and fences, but to open legal venues for those those in need to come to Europe.
Thank you. Thank you for that point. And conclusion, we don't have time for further questions, so I want to ask you, Vladimir and Harald, for participating in this discussion. Thank you for a fantastic cooperation on our paper, which will be out soon in its printed form. It's already online. And thank you to our audience here in the room, as well as online, for watching this event and taking part. The Martin Center is looking forward to further similar events in the near future. And finally, I would like to thank all the colleagues from the Martin Center who put so much work into this event happening. Thank you very much.